Fourth mistake, having two or more people serve jointly as your power of attorney. Sometimes clients will say, well, I can't decide, so I want both of my kids to serve as my power of attorney. It's like, okay, let's talk about that further. Why might that be a good idea or a bad idea? Usually we try to counsel our clients not to have people serve jointly as their power of attorney. The reason for that is sometimes the two people won't agree. Let me give you an example that was, one of the, I mentioned that having a power of attorney is to avoid a court-ordered guardianship. Well, I've seen a situation where the attorney made two people joint as the power of attorney, and that actually led to a guardianship, the opposite of what you would hope for. Well, why is that? Well, here was the situation. The attorney drafted a power of attorney for the husband. And in the power of attorney, the husband said, well, I want my new wife to be my power of attorney. And I also want my son from my prior marriage to be my power of attorney. And I want them to serve jointly. If they serve jointly, when people serve jointly, usually it means that they have to agree on everything that's done, all the financial decisions, how to spend the money, where the care facility will be, what kind of medical treatment, on and on. You can just imagine the scenario. Well, no surprise, stepmom and the son could agree on nothing. As a result, there was a court-ordered guardianship that had to be put into place because they would not agree. Nothing you could do could get them to agree. So the whole idea of having a power of attorney is so you don't get into a guardianship. If you appoint the wrong people as joint and they have to agree on everything, that's kind of a recipe for disaster. And it was in this situation, and there was a court-ordered guardianship. That's just one of the reasons not to appoint two people and say that they have to serve jointly, and agree on all their decisions. From time to time, we do say, okay, you want your child and your new spouse to serve jointly, and there's some good reasons for that. Let's have it so that they can each serve, but their decisions can be independent of one another. They talk all the time, they get along fine, there's no weird dynamics, but maybe somebody is better about writing the checks and somebody is better about doing this, and they're always talking with each other. So you can appoint people to be joint but independent, meaning they can each transact business. That is kind of an exception to the rule. It's pretty unusual. We do it from time to time, but only in the unique situation where it will work. That's what you're always thinking about. Will this work or will this cause more problems? So I'm not going to say that you can never appoint people jointly as long as you say that they're independent in their decision making, but independent ironically means that they're going to talk with each other and share all the information. So that can be done. Usually though, it's not done, because usually having two people to serve as your attorney in fact, as your agent under your power of attorney, usually is a bad idea.